And I think if those trends continue, and they probably will, over the long run, you probably have fewer of the traditional Establishment Clause cases because it's going to be harder for any majority of Protestant conservatives or whatever group it is to control the political process and impose its religious views. You have to have, something like 50% of those to do that, right? At least, to actually dictate policy and law. And if the country becomes more religiously diverse, it's going to be harder and harder to get that 50%, right? Instead, what you might get are more kind of free exercise clause cases where some of these new minority religions, and they're popping up all over the place, and some of them have kind of unusual practices, are going to be targeted. We've seen that a little bit recently. There was a case not too many years ago about going to Church of the Kumu Babalai, which is a case out of Florida, where there's a Santeria religion where they practiced animal sacrifice. And basically, Hialeah was really upset with this. Hialeah, Florida, we're a fussy town. We don't want animal sacrifice going on, all these carcasses around. They basically banned animal sacrifice, right? That got challenged on free exercise grounds, and the court found it to be a violation of the Constitution. Hialeah can't target a particular religion like the Santeria religion. So you're going to see those kinds of issues. We see these kinds of things popping up around the world. France passing laws that target burqas in classrooms, for example. So is there Muslim populations might be subject to some laws that target them. There's a case that the Americans United was involved in a couple of years ago involving a Wiccan soldier. They wanted to have a memorial just like the Christian soldiers who died in Afghanistan got these. And you get Star of David if you're Jewish. A soldier and you died, they put in a little marker in the grave. They wanted a Wiccan one. And the Veterans Administration said, we're not putting a Wiccan symbol on here. And the lower court said, you got to. You can't just pick on Wiccan, but if you what's fair for them is fair for the goose and sauce for gander. You got to let the Wiccans have their little symbol on too. If you got the Star of David, you got the Christian cross on others. So we might have more of those kinds of cases coming down the road in the future. Would be my guess. And let me leave it at that. Although there are some pending cases out there, because a little boy who's involved in a pending case that might. And I could talk about some of these pending cases here if you want me to. If there are any questions, or if you have specific questions about what I've said, I guess we could deal with that. See?
What's your feeling on how Kennedy's going to rule on the big case coming up, which is the California gay marriage?
Good question. Perry versus Schwarzenegger is a case that, if it gets to the Supreme Court, there's issues now, a standing question that the California Supreme Court has to deal with, and they could basically knock it out, and which would have the effect of letting the federal court's decision stand and prevent it from getting to the Supreme Court, because it would be anyone to appeal the decision of the Ninth Circuit. But if it gets to the Ninth Circuit, it'll come down to Justice Kennedy. Surprise, surprise, right? But if you force me to guess, it's a tough case. But Justice Kennedy has a strong sense of history. I think he doesn't want to be on the wrong side of history. And I think he sees which way history is going on gay rights. He wrote the decision in the sodomy case, which found a constitutional right to engage in homosexual sodomy. It was a 5-4 decision. So I have a feeling that if it came down to vote in the Supreme Court, if the Supreme Court does in fact take that case, they'll probably find bans on gay marriage unconstitutional. Some of you might know the Obama administration announced today that it will not, as of today, no longer defend bans on gay marriage while it's in the courts, reversing the policy until today. So things are changing in that way as well. That's actually, of course, the protection case, but there are church-state overtones there as well. Any other questions about this, or else I could talk about some of these other cases coming up?
How do you feel all these cases you cited have either stayed with or strayed from the founder's original intent as far as religion being part of
Well, it's hard to know in these cases where the framers would come down. The public schools are especially difficult because they didn't really have public schools then, so I mean, what would they think about praying in public schools when they didn't have public schools? And they had there was certainly a disagreement about among the framers as to how much prayer should be in the public sphere. But on the other hand, I mean, there were funding religious missions out in Indian territories and things like that. So, I mean, they had an accommodating view of religion overall, I think. But some of the framers, I think, also were of the belief that the values that they had shouldn't necessarily control for generation after generation. They wanted to have some broader values laid down and have them applied by people of their times. So it's hard to know. We've thought about some of these things. Good questions.
As the purist originalist justice, how does Thomas respond to a lot of...
Establishment? What establishment? Actually, Justice Thomas wrote a very interesting decision. He said the Establishment Clause doesn't apply to the states. I mean, if the state, Missouri, wants to become a Pentecostal state and have tax dollars and create the state church of Missouri, that's fine with him. He doesn't think the Establishment Clause applies to the states. It only applies to the federal government, and it only prevents the federal government from establishing a national religion, and that's it. I mean, Justice Scalia even thinks that's kind of cool. So that's what he is. Yeah.
Has a Supreme Court justice ever been impeached?
Has the Supreme Court justice ever been impeached? Impeached in the sense that he was impeached by the House but not convicted by the Senate. Justice Chase was back in 1803 or something. But that's it. There have been a lot of lower court judges that have been. There have been a lot of threats to impeach the justices, but never one successful impeachment.
How does the age of all these justices come into play? Are they kind of allowed to say, I want to, if I'm conservative, I want to retire after Bush's term, instead of Bush can get the next appointment?
Yeah, I mean, they leave the court when they feel like leaving the court.
Yeah, they are forced. I know it's a lifetime sentence, lifetime term, but.
I mean, there have been cases. With Justice Douglas, they had strokes, and, kind of hauled up to the bench, tell her he's alive or dead. But he stayed on the court for a while. And they're entitled to do that. But then, most of them at some point, Justice Stevens is coming to 90 when he retired, but he's still out playing tennis. His older brother is still out there. But he could have stayed on the court for a while. And some retire early. Suited want to have a more private life. By the way, that's the little boy up there, the Native American boy, Gabriel Arocha. Texas says he's got to cut his hair. The school district, he's in kindergarten class. His religious views as a Native American, his hair has sacred properties. He doesn't want to cut his hair. Cases of Fifth Circuit, just a free exercise violation, forcing him to cut his hair. So, I mean, there are some interesting cases out there in the lower court. Some of them are in the free exercise area, some of them are in the Establishment Clause area. We'll see what happens. Any other last questions? Well, thank you for your attention.